Please be seated. We're here for our second live case of the morning. This case is Hudkins versus Hudkins, case number 21-3094. Mr. Hauser, you may proceed. And if you'd be kind enough to let the court know how much time you would like for rebuttal.
Okay, thank you, sir. 20 minutes, huh?
You have 20 minutes total, but how much would you like to reserve, if any? Some don't reserve any.
7.
7 for rebuttal?
Yes, thank you, sir. And may it please the court, my name is Robert Hauser. I practice in West Palm Beach at Sniffen and Spellman, PA. And I represent LaDonna Hudkins, who is the wife in this situation. She's the spouse of an alleged incapacitated person. His name is Keith Hudkins. Sometimes I'll call him the ward. The most important issue today for us is the marital home. The evidence in our case is incredibly simple. This marital home was acquired in 2019, if I'm not mistaken. It was taken in a deed as entirety's property. After the husband had an incident that may have caused him to be incapacitated, we don't concede that he was, but after that incident, the wife used a power of attorney to transfer that house to a trust entirely controlled by her, and there's no question.
So you're saying you're not conceding that the determination of incapacity was proper?
That's true.
Okay. Did you attach the order of incapacity to your notice of appeal?
Not the August 26th order. And it's, by the way, it's too late for us to attack the decision of the trial court to call Mr. Hudkins incapacitated.
So you're not, the issue that is raised in your brief is more to deal with the property transactions, not with whether he is, as I read it in your, I think it may have been in your reply brief, you're more interested in these Medicaid transactions and the property transactions as incapacity rather than the finding of incapacity and the appointment of the guardian. Is that correct?
Right, and I don't think the court has jurisdiction to review the order that actually declares him incapacitated.
Okay, I would agree.
Yeah,
okay.
My problem is the weaponization of that determination in what is really an in personam lawsuit against my client, because, and I do want to get to that incapacity determination if we have time. I think we're going to have plenty of time, 20 minutes. But the marital home is the most material thing here. As I said,
so the marital home was titled as tenancy by the entirety.
Yes, sir.
Correct?
Absolutely
okay.
right. And then
and your client
she
transferred it to herself in her trust. In her trust.
And the
correct?
court, yes, sir. And the court frowned on that. There's no question that the court frowned on that. I don't think that was before the court.
So what are you asking the court to do today? Give the home, since she titled it in her name, to her, or back to tenancy by the entirety?
Well, you could do one of two things. I think the technically correct thing is that this guardianship court didn't have jurisdiction over my client's trust's property at that hearing. That hearing was about whether the ward needed a guardian and who that guardian was going to be, assuming that he's incapacitated. And instead, it sort of morphed into an unnoticed in personam claim against the wife. And that's really where the error is here. It wasn't really the judge's job at that hearing to decide what happens to the house, because it wasn't guardianship property. Now,
was that ever brought up in any, I know there's multiple hearings in this. I was trying to follow the multiple hearings that you had. Was that ever brought up or argued below as to what would happen to the house? Did you ever have the opportunity to argue as to what would happen to the house below?
Our trial lawyer did not raise that specifically. It came up in the other side's closing argument, and they put in a request at the end.
I understand it came up in the request. I'm talking about in the proceedings, other than the closing arguments, was there ever any litigation over that property that you
the facts came in. The facts are known, and those facts were relevant to determine.
Was there ever any litigation about the determination of how this house would ultimately be titled?
I don't think so, but the fact that my client titled the house from entireties
Why
into this
is
trust.
it not waived then, Mr. Hauser, that issue?
Because I can raise the sufficiency of the evidence on appeal for the first time. And I'd like to talk about what the evidence is, okay? The evidence is it was entirety's property. The evidence is that it was moved to my client's trust. And the evidence is that the court frowned on that last transaction, right? And so let's assume that we waived everything and that we walked into court and waived any objection to litigating over that last transaction, okay? Let's assume that my trial lawyer blew it, and he also didn't file a post-trial motion, okay? Let's assume he blew it. The evidence in the case is that that property goes back to entirety's property. The evidence in the case is not mandatory permanent injunction, give the house to them.
So can you explain then, I guess what you're arguing is that there was fundamental error by the court, and that's what brings that in front of us to
I
hear?
think-
And
yes,
so,
sir.
can you explain that?
I think there's a due process problem because this was noticed as a hearing over who's going to be the guardian and what are their powers going to be. That's a due process problem. But let's assume that was waived under Rule 1.530.
But you would agree you can waive due process, correct?
I can't imagine.
You can't imagine?
Due process is fundamental error. If the denial of due process is
Why
fundamental error.
can't you imagine, I mean, if I am, hypothetically, I'm called to a hearing, and the judge starts talking about something I didn't prepare for, is there not an obligation either to bring that up in front of the court, or to file something after it, or to file something to let the court know that it was different than what you anticipated it to be? Or is it just enough to sit on my hands and wait for appeal and say, well, my due process rights were violated?
I'm not familiar with a case that says that if a judge suddenly rules at the end of a case on something that was never before him, that you have to go back to that judge and say, you know what, that wasn't what we were arguing.
Well,
I
let
think
me
that-
ask you, so following up on Judge Jay's question, we also have the condo proceeds, which obviously it appeared everybody thought was going to be argued at a subsequent hearing after the final hearing that you had. All of a sudden, it
It's the
shows up in the closing arguments by the guardian, and then eventually the judge puts that same language in her order, correct?
Right, and it's the
Okay.
same analysis.
So there was a hearing set, though, and then by your client, there was a hearing set, and so she canceled that hearing. How is that, along with the fact that this was in the closing arguments and there was no response to the closing arguments, how was that, following up on Judge Jay's question, how is that not a waiver at that point? And you had an opportunity to file for a motion for reconsideration or rehearing, and that was never done.
Okay, let's assume that we waived due process and it's not fundamental error, okay? I still have Rule 1.530, which is, and that's really the reason I'm telling you what the evidence is in the case.
So does 1.530, though, apply to guardianship proceedings?
Why not? This is a
Because
this is
there's a
litigation.
rule in the guardianship rules that discuss that unless a rule of procedure is in the guardianship rules, that we don't apply those rules of procedure. And 1.530 that I can find is not in the guardianship procedures or in the probate procedures. Can you address that?
Yes, this is an adversary proceeding. I mean, it turned into an adversary proceeding when they tried to make in personam rulings against my client. So you can see sort of the circular problem here. This was...
So I want to make sure I understand that, Mr. Hauser. So you said it turned into an adversary proceeding, and by virtue of it becoming an adversary proceeding, it became a regular civil matter at that point, and then the rules of civil procedure would then apply?
Right, because we're not talking about in rem anymore. When the judge entered a mandatory permanent injunction against my client, saying you have to hand this property over, not just the half that used to belong to the ward, which I could see happening in a future proceeding, your own interest in the property also must be handed over to the ward. A complete forfeiture of her marital constitutional homestead interest in her marital home is gone. And that was all done by surprise, okay? And so to me, that is a due process violation, but the evidence in the record is clear that if the transaction is voided, from entireties to her alone. If it's voided, fine, then it goes back to entireties, and my client still has her marital homestead interest in that house. And the exact same...
So let me ask you about the tenancy, the Ponte Vedra home, and then I want to ask you about the condo fees, kind of the same. The Ponte Vedra home, are you arguing in your brief that that needed to be a separate legal action, that they needed to get permission to file a separate legal action? That should have been a separate legal action under Florida Statute 744.441K? Is that?
No question. No question. But let's assume we waive that.
So as to following up on that, as to the condo. So the condo, prior to any finding of incapacity, I think the facts showed, the condo was held tenancy by the entireties, then it was put in a joint trust, is that correct? Or was it sometime put into a joint trust, correct?
It was never entireties property. It belonged to the ward, and he put it in a trust where he and the wife were together.
Okay, so are you here today saying that the judge was correct in ordering that all those funds from the sale of the condo go into the guardianship account? Are you not contesting that?
No, that's error. Those are trust funds. They're not part of the guardianship estate. The evidence in the case is exactly, I think, as your Honor just recited. They were trust funds. The wife transferred those to a trust that only she controlled in order to sell the house. And again, it's just like the house.
She sold that during the proceedings, correct?
Yes.
So the judge, I think the judge gave her permission to do that?
I don't think the judge stopped her. What the other side was interested in doing was intercepting the proceeds, and the court did intercept the proceeds. My point today here
So are you saying that there needed to be, since the judge, everybody knew the sale was going through, the judge took the proceeds, that there needs to be a separate independent action for that, or just that you didn't get an opportunity to argue that your position as to those funds?
It is technically true that there should have been a separate proceeding to grab those funds, but let's assume that it's okay.
But they may waive that below, correct?
Let's assume that was waived.
Okay.
The evidence in the case is that those funds originate from a joint trust, and if my client was wrong to move it into a trust in order to facilitate the sale as part of the Medicaid planning.
Okay, so then that brings me back to the same question I had before. At the end of the proceedings, there was some discussion by trial, you were not trial counsel below, is that correct? So there was some discussion by trial counsel below asking the judge right at the end of the proceedings, what are we going to do with these funds? And she says, put them in let's put them in the closing arguments. I believe even maybe the ward's attorney spoke up and said, no, we've got a hearing here in a week. And so I guess my question is, you had this hearing that was supposed to be to dispose of these or resolve the issue with these funds, and then it gets canceled. Do you know why it got canceled?
I do not.
Did the petition actually, not only did they cancel, did the petition get withdrawn for those funds? Do you know?
I don't know. And as far as I can tell, it was litigated in that proceeding, and the judge decided...
So your sole argument for those funds today is that you never had an opportunity to be able to argue where those funds would go below?
No, sir, because the judge evidently doesn't need to hear from us. But there is evidence in the case, and the evidence is not disputed.
But there was an opportunity at this hearing, Judge Boatwright just referenced, which was canceled, as I understand it, based on this record, by trial counsel. So the opportunity to deal with the very thing you were arguing on appeal was available, and it was taken away by virtue of the cancellation. So why is that not a waiver?
Because the evidence is in, and the judge made a decision based on the evidence, and the evidence that is in shows that this condo was joint property. It's not guardianship property. There's no evidence that it is guardianship property.
So all of this emanates, and I want to make sure I understand, and I think you said it at the beginning, but if I'm misinterpreting what you said, please tell me, that all of this emanates, these 2 points that you're discussing with us now, emanates from the insufficiency of the evidence to validate the court's ruling. And insufficiency of evidence is always something you can argue on appeal. Is that what you're telling us?
Yes, sir. And the evidence in this case, the judge is wrong. The judge is wrong to say that my client has to give the entirety of the house to the other side. In the worst-case scenario, she has to give the half of the house that was their entirety's interest to the guardianship. That could have been guardianship property if her subsequent deed is invalidated. The evidence in the case that was before the judge is that the condo was in a joint trust. No one's attacking the existence of the joint trust as illegitimate. The evidence in the case is that it's not theirs. The evidence in the case is it belongs in a trust.
Is there a difference between tenancy by the entirety's property versus something being a joint asset? Doesn't the guardianship court have the ability to take joint assets and give them to the guardian for the benefit of the ward?
Not without worrying about the rights of the other trust beneficiary and trustee, and that would be in a proceeding. Like, I agree, this guardianship court could have reached into that trust and accessed some of that money, but not in complete disregard of my client's rights in that same trust. And then the house is more egregious, and I think Your Honor's onto that. The house is more egregious because the house is our entirety's property. If the transaction from entireties to sole trust is invalidated, it goes back to entirety's property. It's my client's house. It's hers. And so and there's a statute that limits the alienability of entirety's property as between a guardian and the other spouse.
Not that you need my warning, Mr.
I see
Hauser,
it.
but you're well into your rebuttal time. But I'd leave that to you if you want to
I
proceed.
see it. I think you understand the property issues. The last issue is incapacity. It's one thing to use this new statutory procedure to put somebody in guardianship where their own appointed attorney doesn't object. Okay, and that happened here. The appointed attorney did nothing to stop this person from being put into guardianship, and we didn't have standing, according to their own arguments, to stop it. That is one thing. But then this same hearsay-based incapacity issue is used at that trial, and this is an objection that we made vociferously at trial. Those reports are hearsay, and yet they were not only admitted to shut down the ward and put him in guardianship, they were used to make these determinations about my client's property in personam against her. And that's error. That is a due process problem, which is why her objection should have been sustained. You can't use that incapacity determination as a weapon against somebody else, even though it's waived against the ward.
She did have an opportunity to go to that hearing. She is an interested party, correct?
Of course.
Okay, so she had an opportunity to go to that hearing, correct?
Of course.
Did she subpoena any of those doctors to testify as to whether he was the incapacity issue?
No.
She had that opportunity, correct?
Theoretically.
Okay, all right.
But it's not my client's burden to prove incapacity in any respect whatsoever. It's actually somebody who's trying to take her property away on the grounds that a transaction was invalid because of his incapacity has to prove incapacity by clear and convincing evidence. There's nothing in the statute that shifts that burden to my client. All my client has to do is put them to their proof, and they only had the hearsay reports, maybe good enough against the ward, not good enough to invalidate third-party transactions against spouse, business partner, contracting party, donee. And imagine all these people out in the world who are doing business with alleged incapacitated people. They can't be bound by a hearsay admission of a report in a court like that. It's hearsay, and it's only binding against the ward, not against the outside world. Thanks very much.
We'll keep the 154 for your rebuttal, Mr. Hauser. Is the appellee prepared to proceed?
I am, Your Honor. Thank you. Good morning. May it please the Court. My name is Keith Cromash with the law firm of Nash & Cromash LLP in Melbourne, and we represent Dr. Matthew Hudkins, the appellee in this case, who is the plenary guardian of the person and property of the ward, Keith Hudkins. I'd like to begin by correcting a misstatement on the part of the appellant in their reply brief, and I think the Court may have picked up on this, but it was alleged in the reply brief that me, as trial counsel, and my client submitted the proposed order to the judge that is being reviewed today. In fact, I didn't submit that proposed order. What happened was the judge requested the parties to submit closing arguments. The parties did submit closing arguments, and the judge prepared her own order. I had nothing to do with that order in terms of writing it.
You did place the request,
Yes.
though, in your closing arguments for, let's just say, for the condo fees when that had not been litigated, had it?
Well, to your point, or I think it was, yeah, Judge Boatwright, you asked the question of whether the property issues had been litigated. And I do want to point out that we filed an emergency motion for authority to initiate legal action, an emergency motion for temporary injunction. That's on the appellant's, or the appellee's appendix, but on pages 9 through 26. That sought to invalidate the memorandum of trust with respect to the Ponte Vedra property, and I think it also, I want to say it also requested a injunction with
So
respect.
I saw the motion or
Yeah.
the petition. I guess the question is, were those issues ever litigated?
Yes, they
Like,
were, and it was, if you take a
Was there
look.
ever litigation giving his client the opportunity to dispute how, let's just say the condo fees in particular, how those condo fees would be distributed?
Yeah, so that hearing, this case, as you know, went over months, and it was many days. We set the hearing for this issue about the property, and we litigated it for the entire day, and it concluded without, or it ended without concluding. There were 3 witnesses who testified at that hearing. There was the ward who testified, attorney David Jacoby testified, he was the Medicaid attorney, and the appellee testified. So granted, the appellant didn't get her opportunity to testify, but if this case had gone on and this hearing had been allowed to continue, she would have had that opportunity. But she certainly had the opportunity to participate. And by the way, David Jacoby was her witness. So it's not as if she didn't have an ample opportunity to participate in the proceedings.
So let me ask you about the Ponte Vedra home specifically. So it was titled as tenants by the entireties.
Yes.
Then, contrary to Mr. Jacoby's recommendation to her, she then records the deed, placing it in her own trust, correct?
That's correct.
Okay. So she was in error, let's just say she was in error there, but wasn't the judge in error giving that property solely to the titling it in the guardian's name solely for the ward? Shouldn't this have gone back to tenancy by the entireties?
Well,
And I guess in following up on that, why would you request that in your closing arguments? Is
Okay.
there some legal authority
Yes.
for that? Okay.
and this is what we argued in the brief, and what I contend today is that, first of all, guardianship, as the court knows, is an equitable proceeding. That's the Hayes versus guardianship of Thompson case out of the Florida Supreme Court. So we know it's an equitable proceeding. We also know from Hayes that the protection of the ward is the overwhelming public policy of guardianship law. So that's sort of the basis for where I started. So the trial court's ruling was both an equitable and legal ruling. And then in addition, as far as legal authority, Section 744-361-12 specifically includes pre-guardianship assets in property that the guardian shall, with court approval, take possession of.
So I'd agree with you on that, but we also have 744.47 or 4571A that the appellant cites to discussing tenancy by the entirety property. I'm going to just read you the last sentence. If the spouse who is not incapacitated joins in the sale, transfer, conveyance, or mortgage of the property. So if that happens, you can transfer the tenancy by the entirety's property, but she did not do that here in this case. So I'm not clear how you're saying that. I understand you're citing this statute and the guardianship rules, but what legal authority do you have to take tenancy by the entirety's property and give it to the guardian? I might be more persuaded on the condo fees, but if you can point to some legal authority that gives you the ability to take tenancy by the entirety's property and give it solely to the guardian for the benefit of the ward, I'd be interested in hearing.
Yeah, well, the case that I cited is the McGilton versus Millman case. That's in our brief. It's a fourth DCA case. And in that case, the guardianship court had the authority to rescind a transaction that occurred before the guardianship.
But that was not tenancy by the entirety property.
That wasn't. And I admit that this issue may not be the strongest issue for the appellee. But one thing I do want...
Same case, though, also, which is a little confusing. They do say they can rescind, but then a couple of paragraphs down, don't they discuss the fact that you need to file an independent legal action to do that?
Which we did, and which wasn't fully heard. So
Did you actually file, so you did get permission and filed an independent legal action in this matter in regards to the house and the condo fees?
well, I would say that we asked for permission by filing the petition, and the court granted the permission by entering the order. So,
But did the court grant permission to pursue the action, or did the court resolve the action?
well, the court, in this case, the court resolved that action.
And is that proper?
I think it is, based upon the authority I cited, but to the extent it's not, there's another aspect to this I want to raise, but to the extent it's not, then the appellant may be correct in that it should go back to T by E, tenants by the entireties. But I do want to point something out, and it's important, because I think where these questions are going is, why didn't we concede error on that point? And I know there's a motion for sanctions pending, and I want to address that. The reason we didn't concede error on this point goes to the capacity issue. If you look at how this brief was, the initial brief was framed, the very first issue on appeal is the trial court erred in finding the ward incapacitated over the appellant's hearsay objections. This despite the fact that the order, as the court pointed out, wasn't even attached to the notice of appeal. And the issue of capacity permeates the entire appeal. In fact, the appellant argues in his brief, or in her brief.
How does the issue of incapacity, though, fall into this idea that you can take a tenancy by the entirety's property owner? And again, I know she should not have, the court said she shouldn't have transferred that. But how does this issue of incapacity then give you the legal authority to then place that solely in the name of the guardian?
It may not, but what I'm speaking to, Your Honor, is why it was necessary to defend the lower court's order in the way that we did. And the reason it was is because this entire appeal was premised on incapacity and the request for relief from the appellant. And I'm pleased to hear that the appellant say that they're not asking to overturn the whole guardianship. But when you read the initial brief, that's exactly what they were asking for. They were asking for basically to terminate the guardianship, to remove Dr. Hudkins as guardian, and basically start from square one, including starting from the finding of incapacity. And that's clearly, I think, improper. I think the finding of incapacity was entirely correct. I don't think there wasn't any error on the part of the judge in that regard. So it was very important to protect the ward and to protect the guardian's obligation of protecting the ward for us to argue that the trial court did not err. And certainly, if there was an error in that order, it wasn't the entire order, but that's the relief that the appellant was asking for, is that reversal of the entire order, not just the portions of the order that they found objectionable.
Okay, so in regard, let's move. I'm going to just ask you a couple of questions about the condo fees.
Okay.
So with the Ponte Vedra home, obviously the title has now been placed in Ms. Hudkins' name, correct? So that title would have to be through a separate legal action, potentially to be transferred back. What about the condo fees themselves? Were you asking to file a separate legal action in regards to the condo fees, or just in regards to the entirety's property?
Well, the separate legal action was only related to the Ponte Vedra property.
Do you think you need to file a separate legal action since that property's already been sold in order to resolve the fee issue?
I don't, and I think, and I'm not sure which of your honors asked the question, but this was addressed during the hearing, and at first the proceeds, because it was sold before the guardianship started, or maybe it was during the guardianship, but the proceeds were at first placed in the appellant's attorney's law firm's trust account, and then after that attorney withdrew and the subsequent trial attorney took over, the court authorized and ordered that the appellant put the proceeds of the condominium in my law firm's trust account, where they were until the conclusion of the guardianship.
Are you aware why the hearing got canceled to resolve the issue with these condo fee, with the condo, these amounts?
Yeah, I'm racking my brain on that. I can't recall why it was canceled. I don't know if it was something on our end, or if it was the appellant's end, or if it might have been the court. I just don't know the answer to that, Your Honor. What I would like to talk a little bit about with my remaining time is the capacity issue. We cited 744-331-3I in support of what the court did, which is to allow the committee reports to come into evidence over the hearsay objections and allowed to be used as substantive evidence of incapacity. And this was entirely correct. As I analyzed in the brief, the 744-331-3I is a relatively new statutory provision. It was added in 2017, and it was a reaction to the Shen case. In the Shen case, the court said that the committee reports are hearsay and that they can't support a finding of incapacity over an objection. And so what happened was the legislature looked at that and it came up with this procedure where only the appellant, or I'm sorry, the AIP or the petitioner has standing to object to the reports. And at that point, they have to do it in writing within 5 days prior to the hearing. And if you don't do it that way, then the reports can come into evidence. And the analysis that we did, including the staff analysis from the House Judiciary Committee, from the staff analysis from the Senate Rules Committee, as well as other committees, shows that this was the thinking of the legislature in coming up with this statutory scheme. And to the point that the appellant makes that, you know, he had a due process, or the appellant had a due process right to object to the committee reports as hearsay because somehow they were used against her, which I want to address that issue also because I don't think that's the case. But the statute, 744-331-3H, which existed before the change to 3I, says that the clerk is only required to serve the committee reports on the AIP and the petitioner, no one else. So it makes sense that only the alleged incapacitated person and the petitioner has the standing to object to the committee reports. That's in the statute. So I think it was entirely appropriate for the lower court to find that the ward was totally incapacitated based on the committee reports. And in addition, the argument that the committee reports were somehow used against the spouse, I think is spurious. I think it's speculative. The hearing on the capacity is a separate case number. The only issue, in other words, it's an MH case number, and you have the guardianship, which is a GA case number. They're totally separate cases.
I think he's already kind of made the point, though, that we don't have jurisdiction. He's agreed to that. I understand his other argument, but I think he's...
Well, he has agreed to that, but my point is that the argument is being made that it was admissible as to the ward, but it's not admissible as to the appellant. That's the argument he makes.
In fact, I believe appellant even argues that they're entitled to litigate that de novo on any sort of action that would follow as it pertains to the interim jurisdiction, right?
That's what they say in their brief, correct. And frankly, I think that's a stretch, to say the least, because, first of all, again, the capacity issue, at the time capacity was being litigated, the spouse's property and the spouse's interests were not even being considered. That wasn't even a factor in the litigation at the time. The only issue before the court during the capacity proceeding was whether the ward had capacity. And at that time, the spouse raised her objections. She said they were hearsay. She argued as hard as she could. But the trial court, I think, got it completely right, relying on 744-3I, and said, yeah, the reports come in, and the trial court could rely on them as...
So your contention is that the appellant did not have the standing to object to the reports on the hearing pertaining to capacity, correct?
Absolutely.
Your fallback or alternative argument is even if the appellant did have such standing to object, they were bound by the requirements of the statute to put it in writing 5 days in advance so as to allow you then to summon the or subpoena the doctors to be present so you can meet your burden.
Exactly. And that's the whole...
They're not permitted to lay in the weeds and wait, object at a hearing, and then you didn't subpoena the witnesses believing that no objection was going to be presented subsequent to statute.
That's exactly right. And that's what the legislature... I think that was the thinking of the legislature.
Statute, in particular, you would agree the statute just says petitioner and then the AIP's attorney, correct?
That's correct.
It does not mention any other... I think that's their argument, is it doesn't mention anybody else.
Well,
so the statute specific on the two parties that are to file the 5 day, the notice within 5 days. Is that correct?
Well, I think the argument is because, I think the appellant's argument is that because the statute only lists 2 people and requires those 2 people to comply with the 5-day rule, then anyone else can object and is not required to follow the 5-day rule. I find that argument to be not persuasive because, well, first of all, the rule of statutory construction that says when the legislature specifically lists items, they intended to exclude the items not listed. That's a pretty basic rule of statutory construction. And plus the other factor that I argued earlier, which is that in the 744-3313H, which is the statute dealing with the service of the reports, you're only required to serve on the AIP's attorney and the petitioner. If those are the only 2 individuals that get service, then how can it be said that people that aren't entitled to service are entitled to object, especially when the statute is specific as to the individuals who are entitled to object.
I want to give you some opportunity. We raised some issues. We asked the appellant some questions on preservation, in particular the two issues that seem to be most hotly contested here, the funds from the condo and the Ponte Vedra home. Do you want to speak on whether they have preserved those arguments for appeal?
Well, yeah, I mean, absolutely. We certainly made the argument in the brief that at the conclusion of or after the trial court entered her order, rather than filing a motion for reconsideration or a motion for rehearing, the appellant went right to appeal. I do believe that they certainly had an obligation to raise this issue with the trial court. If this
Why is that? You have authority for that case?
Well, it's just basic preservation and basic concept that you need to give the trial court the opportunity to rule on an issue as a basis before you can appeal it. Now, I heard what counsel said about Rule 1.510, I believe it is.
530?
530, which is the rehearing rule in the civil realm, which Judge Boatwright pointed out may not even apply to this proceeding. But what say you about that? If the rehearing rule doesn't apply, was there still an obligation to file, and you mentioned a motion for reconsideration, something to bring it back in front of the trial court?
Again, I think well, to your point, I don't know the answer whether the rule of civil procedure applies in this case. I think it's possible that it does. I think counsel's argument that this was a adversary proceeding is correct, and therefore the rule of civil procedure may well apply, but I haven't specifically researched that issue. But to the point that I'm sorry, what was the question, Your Honor? I lost my train of thought.
Well, I think following up on what you said, what should they have done? And I think I hear you saying they should have done more than they did, and by virtue of that, are you saying they waived it?
Well, I would argue that it is waived. I think it is a preservation issue, and we certainly did argue that as one of the arguments. I know that we had to make alternative arguments, and it's certainly possible that it is preserved for appeal or that it didn't need to be preserved for appeal. But I think just as a matter of basic fairness, the lower court should have had an opportunity before this appeal proceeded to review the issue, and she wasn't given that opportunity. And I think everybody concedes that. Unless there are any other questions from the court, I will rely on my brief. I would ask the court to affirm. Certainly, I think the order is sound. I think the only potential issues with the order deal with the property, but certainly this court can affirm as to the guardianship. They can affirm as to the court's finding that the powers of attorney should be suspended. This court can affirm as to the capacity issue, or we don't even have to reach the capacity issue. And as far as the property issues, if the court is not convinced that the appellant or the appellee had an interest, or the guardianship has an interest in these properties pre-guardianship and the trial court was correct, I think then the answer is that the Ponte Vedra property should go back as tenants by the entireties. But I think the condominium proceeds, I think those should remain the way they are, and I think the trial court got that right.
Condominium was not homestead, correct?
No, it was not.
Ponte Vedra was.
It was. That's correct.
Refresh my recollection, was the Ponte Vedra homestead purchased during the course of the marriage?
Yes, it was, I believe. And so for those reasons, we ask the court for the relief requested, and thank you for your time.
Thank you, Mr. Croman. Mr. Hauser, you have a minute 54 for rebuttal.
Thank you. I better talk fast. I'm really tempted to get into the the incapacity issue, because the court got very close to where I wanted to go. I looked at his answer brief. He's got the statutory analysis right, okay? We didn't have standing to object to those committee reports to keep them from putting the ward into guardianship. We couldn't have appealed it. There's nothing to appeal. The only thing we can say is, hey, don't use those against us, because we're about to lose stuff. And it turns out we did. So that's the problem with admitting the committee reports and using them against a third party. The legislature took away a third party's right to object to their use against a ward, and now wards can go into not bankruptcy, into guardianship solely on the basis of hearsay reports. That's true. The problem is taking away the rights of third parties and holding them to that conclusive determination which they had no standing to object to. That can't be. We have to read the code in consistent with due process. Any third party should be able to come in and say, look, I know he's in guardianship, but he's not really incapacitated, and my transaction X, Y, or Z is not infirm. I thought it was ironic that there is some doubt about whether the rehearing rule applies, and yet that rehearing rule is the rule that restates the general rule of appellate practice that it is not necessary to tell a judge that their own ruling is not supported by evidence. That's something I can raise on appeal without preservation. So the key issue here is the house. The house belongs to the wife at a very minimum at her entirety's property, but technically it belongs to her trust. But if we waived that issue, we waived it. It belongs to her by the entireties, and the injunction needs to be reversed. The exact same analysis applies to the condo proceeds. They belong in a joint trust. That's where they should have gone. They were never guardianship property. And so we asked the court to reverse and provide some relief to the ward's spouse. Thanks
Thank you,
very
Mr.
much.
Hauser. Thank you, Mr. Croman. Well presented on both sides. We are now in recess.